Hello, everyone. Welcome to this YouTube channel of K-Leaders. I'm Frances Chan.
I'm Carmen Chi.
Hi, Carmen. We are on the episode 5 already.
Yes.
So thank you very much for your support. And we will
you.
give you more contents, more sharing going forward.
Yes.
So what are we talking about this episode?
Well, I think last time we spent 2 episodes talking about shareholders agreement. So this time, let's talk about when you have a shareholders agreement and when you also have a couple of shareholders, then how do you actually implement some of the provisions in your shareholders agreement when you're actually passing your board resolutions and your shareholders resolutions? Now, last time we talked about how to implement control at board level. Remember last time I mentioned that, for shareholder, sometimes they may nominate a preferred director to be at the board. Now that when we're talking about passing board resolutions, let's talk about what it is actually like in reality. Now, passing resolutions, passing directors' resolutions. So when do you need to pass board resolutions? Well, of course, like for some of the company's internal affairs, you do need to pass resolutions, such as if you're changing your company's registered address, or more pragmatic matters, such as if you're opening a bank account, right?
Yeah, change company name or you appoint an agent for you.
Yeah, so these are some of the things that you will need to pass board resolutions. So what about commercial matters? What happens if you have a shareholders agreement in place already? Before you pass your board resolutions, of course, like you'll have to go into your shareholders agreement just to look at the provisions, just to see, what are some of the requirements for holding the board meeting? So aside from the requirements that's required by law and also your articles of association, what are the requirements for convening a valid board meeting? To convene a valid board meeting, of course, you've got to give notice, right?
Yes.
You have to give notice to all the directors. With this notice, what is valid notice? Does it have to be in writing? Can it be just by way of oral notice? Well, it really depends. And also, like, what's the notice period? Remember in episode 2, I talked about directors having the responsibility of running the company and also going out and contract on behalf of the company and managing the day-to-day operation of the company, right? Let's say if something urgent came up and it would require the attention of all the directors to sit down together to deal with something urgently. If the notice period, let's say for board meetings, it's set out in the articles being, let's say, like 7 days, well, then that provision doesn't really work for the situation that I just spoke of. So it really depends on the situation when it comes to the notice period. But the most important thing is that you give clear notice to all the directors so that they're well informed of when the director meeting will take place, where and what matters are going to be discussed.
I think it is very fundamental that you need to serve the notice properly. Since it is something internal, the company ordinance do not provide regulations as how to convene a meeting or serve the notice. So you have to look at the Article of Association for the requirements.
Now, so in addition to notices, there's quorum. Usually the quorum requirement is set out in the Articles of Association. But if you have a shareholders agreement in place, a lot of time the quorum requirement will also be set out in the shareholders agreement.
Yes.
So when it comes to quorum, it's very important that after the director shows up and attendance is taken, that they continue to stay throughout the entire meeting just to meet the quorum requirement.
Yes.
Yeah, Frances, I actually just want to ask you,
Yes.
so do some of your clients ask you to prepare the board meeting notice?
Oh, yes, definitely. Especially for those cases where there are third-party shareholders, then they would ask us to properly prepare the resolutions, or they prepare the draft and recommend on it.
Okay. So, as a company secretary, and I'm sure like a lot of your clients, they may probably ask you to attend board meeting, right? As a company secretary.
Yes, sometimes they do.
To take minutes or...
Yeah. Our major role is to suggest to the client how to convey the meeting in a proper manner, and then help them to take the minutes.
Right. Okay. So there's one thing I want to just point out to everyone. So at the start of a board meeting, normally what would happen is that all the directors, they will elect a chairperson, and this chairperson basically has the responsibility of running the board meeting. Something to note, and sometimes it's also stated in the Articles of Association, is that this particular chairperson has a casting vote when there's an equality of vote. I suggest that all of you just bear in mind that when the chairman has a casting vote, it also means that basically this particular director has 2 votes. If you don't want that person to have a casting vote, then you probably need to change your articles of association, and you will also reflect the same in the shareholders agreement.
Yes.
We've talked about board meetings, so why don't we go ahead and talk about shareholders meeting? Yeah. So for a shareholders meeting, or a general meeting, as this is what it's being referred to under the company's ordinance, I just want to point out something to everyone. I think a lot of times, and certainly like some of my clients, they're under the conception that voting usually takes place by poll, meaning it's 1 vote for 1 share. But this is actually something you will need to request before the start of the general meeting, in the absence of which usually voting takes place by hand, meaning one person, one vote. Because of this, usually in your shareholders agreement, you will see provisions that says that while all the shareholders needs to ensure that voting will take place by way of a poll.
I think some of the cases where my client whose shareholders cannot present at the meeting,
Right.
then they will ask what they can do, and I would suggest them to appoint a proxy if they're individual shareholder, or if it is a corporation, they need to appoint some individual to represent them to attend the meeting. So there will be a form of authorized representative for them to fill out.
Right.
And their notice period for serving the form of proxy normally is 48 hours before the time of the holding of the meeting. And for the appointment of representative, then it can be any time you present the form to the chairman of the meeting.
Right. So do you normally help your client prepare this proxy form?
Yes, actually, when we are helping client to convey the meeting, we'll prepare the whole set of documents, which include these proxy forms.
Okay. So Francis, it sounds like you're actually quite involved in some of your clients' internal affairs.
Yes.
So I know that a lot of your clients are actually international clients. They're actually
Yes.
like large corporations. So I just want to ask you,
Yes.
a lot of them would actually have like shareholders agreement in place, right? So do they voluntarily actually give you a copy of the shareholders agreement just so that you can, well, you're looking after their companies just so that you can do your job properly?
Strictly speaking, they should, but in fact they don't. When we realize that they are third-party shareholder, we normally will actively ask the client whether they have that shareholders agreement, and if yes, then please give me a copy. Because as company secretary, we not only work on the article association, we also need to look at the shareholders agreement
Right.
to see if any conflicting requirements between the documents. So if there are some different requirements among these 2 documents, then we will need to find the one with stricter terms, and then we'll follow that terms.
You see, there's a reason why I want to like bring this up. Remember last time when we talked about shareholders agreement? Remember we talked about quorum at the shareholders level. So remember I also mentioned to everyone that I suggested everyone would prepare like 2 lists of commercial
Yes.
important matters, one for directors to approve and the other one is for the shareholders to approve.
Yes.
So if you were to have a shareholders meeting to approve one of these important commercial transactions, then of course you'll have to go back to your shareholders agreement to look at the quorum requirement and the number of votes that are required in order to pass that particular important commercial transaction. So sometimes it may be the requirement that it would require maybe 51% affirmative votes, or sometimes it may be 75%, or sometimes for really important commercial matters, I've also seen the requirements requiring 95% affirmative votes. So this is something that I just want to point out to everyone.
Thank you.
Now, In order to hold and convene a valid shareholders meeting, there are certain things you do need to satisfy. In addition to quorum, of course, there's notice, just like a directors meeting. Why is it important? Well, I think Francis also mentioned earlier is that the company's ordinance does set out the requirements, the content of the notice. But for a shareholders meeting, a lot of times the notice requirements and the notice period, they're actually set out in the articles of association, and it's also set out in the shareholders agreement. See, if you were to look into some of the shareholders dispute cases that you see, one shareholder may dispute the fact that certain resolutions were invalidly passed. So it's actually, to me, I think it's actually quite important that shareholders meetings are validly convened. Sometimes notices are not properly given. So what does it mean by that? So I've read a judgment where a notice had no place, no time specified, and also the notice period was basically insufficient because the requirement was that it would need at least 14 days, but less than 14 days was given. In the end, the judge basically commented and ruled that the shareholders meeting was not properly convened, and that resolution, well, wasn't really validly passed.
Maybe I also want to add to this. Notice is important other than the content that you mentioned. If you are passing special resolutions, remember to state clearly that it is a special resolution. And if it's an annual general meeting, then you need to say it's an annual general meeting in the notice. And we as a company secretary will have to dispatch the notice to the shareholders, and we rely upon the registered members to arrange the distribution. So if you already changed your address, remember to notify the company to update your address. Otherwise, you will not be able to receive the notice properly.
I have one question.
Okay.
So what is so special about special resolution?
Yeah, I think actually the company ordinance do specify that certain events do require special resolution. For example, if you want to amalgamate amongst your group companies in Hong Kong, then the ordinance already state it very clear is a special resolution. For certain capital reduction cases, they also specify it's a special resolution.
So it's basically resolutions that would require a 75% affirmative vote of all the shareholders.
Yes.
And these decisions are actually quite important to the company.
Yes, definitely. But remember, sometimes the client consider the resolution is special, but it's not defined in the ordinance as special. So one point I want to raise is because if you are a special resolution, then under the ordinance, you are required to file a copy of that special resolution to the registry for uploading to public records. So if you were not really that special resolution under the ordinance, you may think about whether you want to call it a special resolution.
Now, hey, Francis, so I'm guessing with COVID, a lot of your clients, well, they're probably situated outside of Hong Kong. And I also know that shareholders, they don't generally need to be in one place in order to have a shareholders meeting, right?
Yes, I think if the company already incorporated for some years ago, then the articles may not allow meetings to be held in different places. But for those newly incorporated, maybe incorporated for during the past 10 years, then the article already include an update clause which allow them to hold meetings at different places. If that's the case, then you can hold a Zoom meeting anywhere, or some party is present in the office, but some dial in to join the meeting.
Okay, but that has to be allowed under the Articles of Association.
Yes, I believe so. Yeah. And one thing very interesting, when the COVID-19 unfortunately come to Hong Kong, and there's some social distancing requirements, then when I'm working, then I receive a phone call from my counterpart, and they said, "Oh, do you know, Francis, there's a police coming to an annual general meeting." I said, what happens? Because they're in breach of the social distancing requirements.
Or the gathering ban requirements.
Yes. So I find it very strange, but because the annual general meeting at that time is still convened physically.
Right.
So then the petitioner, like us, will have the question in mind, then how to go forward then. I don't want to see the police every time when we call the AGM. Then I think the company registry do issue a guideline very quickly. So we as petitioner do know how to continue with the AGM if physical meeting is required. So you can download a copy at the company registry website.
Well, then, of course, you can always pass a written resolution to be signed by all shareholders. But I also know that under the company's ordinance, not everything can be done by way of a written resolution.
You are correct. Because the ordinance do specify that in 2 occasions, written resolutions will not be allowed. The first occasion is you want to remove your auditors. The second one is to remove your directors.
So why did we just spend so much time talking to you about the importance of passing valid resolutions? Well, it really is because, in the event of disputes among shareholders over certain decisions or resolutions that's passed by the company or the shareholders, then at least you have some sort of evidence to show that the resolutions were validly passed and it was also done in accordance with the applicable law and also your shareholders' agreement.
Okay, so Carmen, we talk about lots of about the resolutions this time.
Yeah.
So what will we cover next episode?
Well, I think we spent sufficient time just talking about companies' formation. I think next time we will start a series on how to get your company to be investor ready from a legal perspective.
Compliance. So pay attention to our forthcoming episode. I noticed that the Lunar New Year will come 3 days later.
Oh, yeah.
Yeah, so happy Lunar New Year and a very good year of Oz.
Yeah, so Happy New Year, everyone. Thank you.
Thank you for watching. See you next time. Bye-bye.
Bye.
Thank you for watching this video. If you like it, please give us a like and subscribe and share with your friends. Look forward to your continued support. See you next time. Bye-bye.